Probation wants tighter restrictions, but the judge isn't convinced. This moment shows how one decision can change someone's future path.
Then in the other case, he still has an affirmative finding of family violence, so it's the same.
Yes, Judge.
All right, so this is what the court will do then. In cause number 2023 CR 3543, the court is finding violation of condition number 1 true. The court will deny the motion, and that case will expire on August 24th, 2023. I'm sorry, 2025. Thank you. And then in cause number 2024 CR 4456, court is finding violation of condition number 1 true. The court will take in consideration 2025 PF 24726. All right, and then I really don't see the need for, as everybody stated, I really don't see the need for outpatient treatment or probation. Do you see the need for outpatient treatment? All right. So this is what needs to happen, though. Whatever your prescription is, it's not a free pass for you to use more than you're supposed to be using. You understand?
Yes, sir.
And probation, I see that it's for PTSD.
The first one was for my ACL, MCL. I have full reconstruction surgery on my knee. I fractured my lower back. I'm a barber. My back hurts. My knees kill me. Both of them are torn. And my dad was in the military, so all that's documented through it in the hospital.
So is it for PTSD or not?
Yes, this one is. Yes, no.
All right. So is there anything we need to do to address the PTSD probation? All right. All right, then those are the court's orders.
Thank you, Judge.
You need to make sure, we're off the record, you need to make sure that you complete all these programs. And even though your probation officer is telling you, well, we can start at this time, just do it. Get it out of the way. Complete it. You understand? Is there anything else?
Yes, Judge. As part of his bond condition, we put him on GPS partial. I don't know if we need a separate order to remove it this morning or today.
State, do you have any objection to the removal of GPS? He's on GPS.
It's part of the bond condition the judge gave a couple of weeks ago.
No, Judge. I mean, I think one of my questions was in the new case, he was out on St. Mary's buying the product, and that was just a concern. I didn't know what time that was at. I just want to make sure you're following probation rules, as in some type of curfew of not being out late.
All right, so this is what we'll do. We'll continue with partial GPS.
The GPS monitor debate is classic courtroom tension, control versus freedom. Should daily survival outweigh strict surveillance?
For like a year, 2 years.
You need to speak to the state about that. Your attorney needs to speak to the state about that. I'll let them confer with the state. So confer with the state about that.
Judge.
You're welcome.
One.
You too.
Yeah.
All right, we're back on the record.
Mr. Gerhan has no objection to tracking for what purposes.
All right.
Unless it's wrong.
All right. Probation. His GPS device, it'll just be for tracking only for now. And I know it's through pretrial service, but we'll come back in 30 days. Jose Armando Rodriguez. Hello.
Good morning, Judge.
Good morning. How are you doing?
All right. How are you?
Oh, I'm doing great. It's Monday. It's new beginnings.
Yeah.
So he's in federal custody.
He is in federal custody. I did have contact with the federal public defenders, and he was sentenced to 10 months. He has been in federal custody since February. So I'm estimating around the end of November, around the 10th.
Just 1 second. State, on Jose Armando Jr.,
Yes, Judge.
I appreciate everything that you're saying, but until I see the motion, there's nothing I can do.
I'm just trying to give heads
You're-
up.
you're-
I know you are.
You're giving me a jacket cover on the book. You're like, hey, let me just tell you what's going to happen in the jacket cover.
I'm transparent, Judge.
Yeah, no, I appreciate that. So once you have that before me, then I'll take it out.
I'll be right back as soon as I can get it to the judge.
All right, thank you. Sure. This is what we get that. All right, who's here? Larry Garcia. Are there any applications in this case?
No, Your Honor.
All right, court is calling 2025 CR 007787 State versus Larry R. Garcia. Can I have parties announced?
Lauren Espinoza for the state of Texas.
Robert Gaona for the defendant.
And are you Mr. Garcia?
Correct, Your Honor.
Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Garcia, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Garcia, did you review the court admonishments with your attorney?
Yes, I did, Your Honor.
Did you understand it?
I did, Your Honor.
Did you sign it in all the appropriate places?
I did, Your Honor.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea agreement with the state, the court does not have to follow that plea. If for any reason I don't follow your plea bargain agreement and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I do, Your Honor.
All right. In probation, this is not an application. Counsel, I'm sorry, sir. Did you understand you have a right to jury trial?
Yes, Your Honor.
A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
By entering the plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
I am, Your Honor.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did, Your Honor.
All right. According to the plea, the state is asking that your punishment be assessed at 108 days in the Bexar County Jail under 1244, and there's a $500 fine and no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney?
Yes, Your Honor.
Did you understand it
I did.
and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I did, Your Honor.
Counsel, are there any such motions?
No, Judge.
To the offenses charged, how do you plead? Guilty, not guilty, or no contest?
I'm guilty, Your Honor.
State, any evidence?
Yes, Your Honor. State offers into evidence what has been marked as State's Exhibit 1 in all attachments.
Objection.
All right, State, you may be excused. Did you review the waiver and stipulations with your attorney?
Oh, yes, Your Honor.
Did you understand it?
I did, Your Honor.
Did you sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial?
Oh, yes, Your Honor.
It's a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand?
I understood.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
I understand, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. Cindy, do you need a cough drop?
I've got one.
Okay. All right. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Only to accept the plea bargain we worked out with the state, give them credit for time served, and the judge is satisfied.
All right. The court will find you guilty as previously stated. The court will sentence you to 108 days in the Bexar County Jail under 1244. The court will give you credit for any time served. There is a $500 fine, time and money to run concurrently. Counsel, does he have exactly 108 days?
On the docket sheet, it says 107. Judge. So
All right. So here's the thing. With regards to jail time credit, I can only give you credit for the amount of time you've served day for day. The sheriff's office, they're in charge of whether you receive 2 for 1 or 3 for 1. I'm not in charge of that. What I can tell you is I've entered a sentence of you of 108 days in the Bexar County Jail. So if you have 107 days today, maybe they'll release you today, or maybe they will say you owe them another day. That's completely up to the jail. Do you understand?
I understand that.
Now, if they keep you there past 108 days, then your attorney comes back here and we'll find out what's going on.
I understand.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I did, Your Honor.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You're going to have to change your life. How old are you?
35.
All right, you're 35. Now, you're receiving a guilty verdict in this case. That's the easy way out for you. And you're like, hey, this is great because I want to be out of jail either today or tomorrow. At midnight,
The judge ends with a chilling truth. The last time you use could be the last time. Not just a warning, but a life or death reality check.
107 days, probably gone through detox. What's going to end up happening is you have these plans, right? I'm never going to use again. I'm getting my life together. I'm going to get my family back in my life. And then the next thing you do, you hit freedom. You smell the air. You get involved with somebody because you're supposed to change people, places, and things. And the next thing you know, you're using. And the last time you use could be the last time you use. When you get out of jail, you know what the first thing you should do before you call family or anybody and make promises about I'm changing my life? You need to find yourself a meeting and go to a sober support meeting. You need to find yourself a transitional sober house to live in. If you cannot find any of those things, you come back here. I'll pick up the phone, call somebody to help you. But nobody can help you if you don't want to help yourself. You understand? So don't call family making promises that you're going to maintain your sobriety when you haven't been tested yet. You understand?
I understand.
All right. Good luck to you, okay?
Thank you.
You're welcome. Miller?
ready on that, Judge.
All right, Mr. Miller, come down. Okay, I'm assuming this is just a late indictment, even though it has 2023.
MTR.
I think that's
It's on page 6. This is a motion to revoke.
There is a motion to revoke, but he also has several unindicted cases, Judge.
Are we proceeding on the motion to revoke?
Not at this current time, Judge. One discovery on the others. I mean,
Okay.
he has 1, 2, 3, 4 additional cases, and we had an opportunity to look at it today. I didn't really have an opportunity to evaluate those, and I was hoping to get a small reset to look at that, because I think that some of them are going to be taken care of in an intake, and I just didn't want to hold that against him.
Okay.
Yeah.
So when do y'all want this recalled back?
Judge, I'm fine with next week. I've got 2 trial settings here next week, so you're going to see plenty of me.
All right. Do y'all want to recall this back for the 25th or the 26th or the 28th?
28th would probably be the best, Judge, so that we could get a little time just to, if that's okay, Mr.
Yeah, and that's one of the trial settings that I actually have. It's actually a discovery setting.